Hey guys, welcome to today's impromptu episode of the Law of Self-Defense. For those who do not know, I am attorney Andrew Branca for Law of Self-Defense. Welcome, make yourselves comfortable. Let me make sure everything is streaming as it should, and it certainly looks like it is. All right, that's great. So we're here to talk about the Aaron Dean murder trial. He's charged with murder in the death of Atatiana Jefferson. This is the case where he was then a Fort Worth, Texas police officer. He was called to, in effect, a burglary in process call to a house that had for several hours and until up to 2:30 a.m. Had its doors wide open in the cold, in the winter. The neighbors were concerned. They'd never seen the doors like that before, so they called the police. It was reported as a open structure call, which is treated as a burglary in progress call. The police are under SOP not to announce their presence in such a call, so they didn't. They got to the house. They began to look around the house to see what was going on, and about a minute and 15 seconds into their observation around the house, one of the officers, Aaron Dean, looked through a window into the home, and on the other side of the window was apparently Atatiana Jefferson raising a pistol at him. He fired a single shot, struck her in the heart, mortal wound, and she would die within a few seconds after that. Within 2 days, he was fired as a police officer, and he was charged with murder. And we're following his murder trial now. And we had some fairly stunning news yesterday. Before I get to that, I do want to mention the sponsor of today's program, which is none other than, come on, I know it's here someplace. Here we go. American Law Courses. These are law school level courses we teach under the American Law Courses umbrella with a number of expert professors. These are law school level courses taught at a fraction of the time and a fraction of the cost of actual law school, but the same level of education and without the toxic politics of law schools today. If you'd like to learn the law at a law school level, if you've ever wondered what it would be like to attend law school and be able to do it at your convenience and on the cheap, but get that same level of education, this is something you should seriously take a look at. We're just finishing up. Yesterday was the last criminal law class for the fall semester. The students are currently doing the final exam to get their certification. The second week of January, we start the spring semester with 2 new courses, Property and Evidence, typical first-year law school courses. We have excellent professors selected for those, and we're still in the pre-registration period this week, folks. So if you want to save 50%, more than $1,000 off of each of those 2 classes, Evidence and Property, or either one if you only want to take one, now would be the time to take a look at this and register. You can do that at AmericanLawCourses.com. We have a lot of other courses in the pipeline. This is an ongoing process. We have constitutional law, criminal procedure, criminal justice, and more coming. And you can sign up for the entire bundle of courses, and that would save you a tremendous amount of money. But again, you can learn more about that at AmericanLawCourses.com. Okay, so where are we at? Where are we at with this trial? We had a surprise yesterday. So the trial is really only 2 full days in. Now it ran Monday, Tuesday, and Wednesday, but Monday was a half day because the attorney who had been the lead counsel for the defense died last week. And so they had his funeral on Monday afternoon. So we really only had court in the morning for half a day. Then we had court all day Tuesday. And yesterday we had about a half a day of court. And then in the early afternoon, the cameras were turned off. The judge informed the court that he had some things to discuss with the attorneys. The jury was dismissed. The gallery was dismissed. And we learned after the fact that what actually happened was the state abruptly rested, done presenting their case in chief, which shocked and surprised everybody because the state hasn't accomplished anything yet. Remarkably enough, in fact, it was so surprising that the defense simply they weren't prepared. They weren't anticipating having to present their case in chief, having to get their witnesses into the courtroom until next week. And the judge was so sympathetic to the defense's position, he also expected the state to be continuing throughout this week in this murder trial, high-profile murder trial, that he told the defense, well, just take them, we'll recess for the rest of the week. Just take the rest of the week, as if the state had continued to schedule your witnesses and all that. So clearly, everybody was surprised by this turn of events. I think I may have a news article here that I can pull up that shares some of this detail that came out only after the state rested. Let's see. Here it is. So this says state rest case after just 3 days in former Fort Worth officer's murder trial. So 3 calendar days, but really 2 days of testimony. 2 days of state's testimony. And the state hasn't accomplished what it needs to accomplish on the legal merits for this case. So it's the announcement came as a surprise to court observers. And I'm sure it came as a surprise to the court, meaning the judge, and certainly to the defense, who expected a lot more from such a high-profile case. We've been talking all along in our live coverage of the court proceedings that the state isn't delivering very much in terms of what it needs to accomplish. Now, what does it need to accomplish? They've charged this defendant, Aaron Dean, former Fort Worth police officer, with murder. Intentional murder, first-degree felony, good for 99 years if convicted under Texas law. And he's raised the legal defense of self-defense. So the state has to disprove the legal defense of self-defense beyond a reasonable doubt. Now, they don't have to disprove it in its entirety. Any claim of self-defense is made up of 5 elements: innocence, imminence, proportionality, avoidance, and reasonableness. Up to 5 elements. By the way, you can get this cheat sheet for free, folks. We make it available for free. It lists those 5 elements. It gives a brief description of each. It's just a PDF download. You can get this at lawofselfdefense.com/elements. Now, for our purpose in this case, avoidance is off the table as an element. It's not required. It's effectively legally waived for a variety of reasons. One is that Texas is a hard stand your ground state, so there's generally not a legal duty to retreat anyway. There wouldn't have been time or opportunity to retreat given the physical situation, the constraints on movement that the officer faced, the time he had to respond to the apparent threat. And there's never a legal duty unless it's practical to exercise that legal duty. You can't legally require people to do things that are physically impossible. And in any case, this was an officer appropriately consistent with his training and the department's standard operating procedures, investigating a potential burglary in progress, which could easily turn into a hostage situation. That's why the standard operating procedure is to not announce your presence when you arrive at an apparent burglary in progress. So we don't have avoidance. So that leaves 4 elements: innocence, imminence, proportionality, and reasonableness. Innocence, the state would have to prove beyond a reasonable doubt that this officer was acting unlawfully. Nope, that wasn't happening. There's no evidence to that effect. He was following all procedures. Imminence, they would have to show beyond a reasonable doubt that the threat he was facing was either a past threat that was over or a speculative future threat that may never happen. But in fact, this threat was happening, according to virtually all the testimony in this case, including the key witness who changed his testimony to make it more favorable to the state, that this gun was being raised. It was an imminent threat. Proportionality. What was the intensity of threat? Was it a deadly force threat against which deadly defensive force can be used? Yes, it was a gun. A gun is a deadly force threat. And reasonableness. Was the officer acting reasonably? Did he reasonably perceive a gun, for example? Yes, a gun was recovered from the victim in this case. Was he acting consistent with his department's policies? Yes, he was acting consistent with the department's policies. There's no evidence to the contrary, and a lot of evidence consistent with that. So I don't see any of these elements being vulnerable to disproof beyond a reasonable doubt, which means the claim of self-defense would be sufficient to be a justification against a murder conviction. Now, a lesser included charge of first-degree murder under Texas law is reckless manslaughter. So in theory, the state might try to argue that, well, even if it wasn't an intentional killing inconsistent with self-defense, it was nevertheless reckless. And reckless manslaughter under Texas law is a second-degree felony, good for 20 years in prison. The difficulty for the state here is recklessness in the criminal context requires the unjustified creation of a risk of death. and then someone dies as a result to make it reckless manslaughter. Drunk driving would be an example of that. Alec Baldwin would be an example of that when he pointed a gun, a real gun, a gun he knew was real, at another human being, Helena Hutchins, without ensuring first that it was unloaded. Here, the officer doesn't appear to have done anything that was unjustified. You might argue that his sneaking around the home at 2:30 a.m. to investigate the scene of an apparent burglary in progress created risk, as we see by the event itself, but it was not an unjustified risk. It was a justified risk. That's his job. That's what he was trained to do. That's what his department requires. He had another officer with him doing exactly the same thing, because that's what they're trained to do. As she testified, the partner officer, the backup officer, testified at trial. So the state would have to prove recklessness beyond a reasonable doubt, and there's simply no evidence to support that at all. Now, the one piece of evidence that might undercut the self-defense claim and therefore leave the murder conviction as a viable option is there was testimony from the only non-police eyewitness, the 8-year-old child who was being babysat by the victim here. And that child on the witness stand testified that he was watching his aunt, the victim here, Atatiana Jefferson, and she never pointed the gun at the window, never pointed the gun at the officer. Well, if the gun wasn't pointed at the officer, maybe it undercuts the reasonableness of his perception of an imminent deadly force threat. The problem with that testimony on the witness stand is the jury was also presented with video testimony taken 2 hours after the shooting, in which this the kid's now 11 years old. At the time of the event, he was 8 years old. At the 8-year-old, 2 hours after the event, explicitly told the interviewer that his aunt had pointed the gun at the window. And that testimony is going to be, ought to be given, much more weight and credibility than what a now 11-year-old remembers from 3 years prior, especially, frankly, when his family, the family of the victim here, is suing the Fort Worth Police Department and the city for $10 million. And that suit has a lot more chance of being successful if this kid changed his testimony in this particular way. Also, while he was being cross-examined by the defense, very gently, understandably enough, he's an 11-year-old, there was a woman in the gallery gesturing to him throughout his testimony, which suggests he was being guided in his testimony. That woman was actually identified by the court and thrown out of the courtroom by the judge. And the jury would have seen all that too. So it's this new, suddenly, the first time, even the prosecutors were obliged to tell the court, Your Honor, this is the first time he's ever testified that the gun was not pointed at the window, to our knowledge. And that was a Brady requirement. Brady, U.S. Supreme Court, if the state comes into evidence that's exculpatory, favorable to the defense, they're obligated to give it to the defense. They knew the kid had never before said the gun was not pointed at the window. So they made that Brady disclosure in court. So not a very strong position for the state. And we kept wondering when they were going to present evidence that could possibly undercut any one of the elements of self-defense beyond a reasonable doubt, or be evidence sufficient to constitute recklessness, proof of recklessness beyond a reasonable doubt. And they just never did it. They never did it. Now, for law of self-defense members, and if you're not a law of self-defense member, I have to ask why. Because as a law of self-defense member, not only do you get all your questions answered in the member chat, as opposed to having to pay $5 at a time to get questions answered as super chats here on Law of Self-Defense. Where is my little... I don't seem to have that banner now. That's interesting. Oh, here it is. We also get exclusive content. So a piece of content we put up yesterday was a recap of the first 2 days of the trial with my personal notes that I take as the trial's proceeding, along with the testimony of each witness chopped up to make it more efficient to watch, chopped up into their direct examination, their cross, their redirect, their recross, and so forth. So you can just quickly get to the witness testimony you're most interested in, and my notes can help guide you as to what might be most interesting. But yesterday's, so if you're a Law of Self-Defense member, go over to the blog and you can catch all that. I'm not going to recap that all here. I don't have time, frankly. I have a doctor's appointment shortly. So this is going to be a relatively short show for me. But I do want to, let me pull up my notes from yesterday. I'm going to do the same recap, by the way, for the Law of Self-Defense members for yesterday. We're just having some trouble with the video, so I wasn't able to get that out last night. hopefully this afternoon I'll be able to do that. But so the witnesses we have had, the first witness was that 11-year-old child who was 8 years old at the time. His testimony about the gun not being pointed was immediately contradicted by video evidence of the interview 2 hours after, in which he said the gun was pointed, and of course by the person in the gallery gesticulating to him and being thrown out of court. That was really the child testified on Monday. That was really the only witness on Monday after the opening arguments. Then on Tuesday, we had that video shown. That was the first quote unquote witness of Tuesday, the video contradicting the child's prior day testimony. Then we had hours of testimony from the partner, the backup officer on the scene, police officer Carol Darch, whose testimony was entirely consistent with the defense narrative. Very little the state was able to pull up. The state did say, well, you know, there's a bunch of procedures for investigating a burglary. Did you do all the things on the list? And they hadn't, because of course they were only on the scene for 1.25 minutes before the shooting happened. So procedures take time to implement. So obviously they hadn't checked all the boxes, but that wasn't for reasons of criminal liability. So we had Carol Darch. Then after Carol Darch, we had the Abriel Talbert, who was the woman who took the non-emergency call from the neighbors that ended up sending the police to the home. She didn't have anything to say that was favorable for the state. In fact, it was harmful to the state. The state tried to question her on why she coded this call to the police as an open structure call, a high priority call, an apparent burglary in process call. And she said, well, because it involved a structure that was open, obviously. So she didn't have anything to say. And by the way, that wouldn't have mattered anyway. If she had improperly coded the event, that's not a reflection on the defendant. The defendant's responding to the information he was provided. If he's provided bad information, that's not on him, but it wasn't bad information. And then we had James Smith was the last witness on Tuesday. This was the neighbor across the street who called the police about the doors being open. Apparently the doors have been open from 10 p.m., still open at 2:30 in the morning, and that's when he called police. He actually walked across the street, took a look, but he didn't want to knock on the door or alert anybody inside because he thought it was dangerous to do that. That's why he called the police. When he heard that someone had been killed a short while later, he assumed it had been an officer killed by a bad actor inside the home. So even he had a reasonable perception that this was a dangerous situation. And then yesterday we had a crime scene investigator who ran a Leica scanner, which is a device that kind of scans an area, matches it up with pictures, creates kind of a 3D visualization of what a space looked like. But he didn't have anything to say that was damaging to the defense. Spent a lot of time with him, but it wasn't very productive for the defense. The cross wasn't particularly productive either, but it doesn't have to be if the direct by the state wasn't very productive. Then we had Detective Doug Roloff, who was one of the crime scene investigators, and also Officer Valgaris, I believe is the name, or maybe he just mentioned Valgaris, but a crime scene investigator, and they didn't have anything. They only arrived on the scene afterwards. They didn't have anything to say that was harmful to the defense. Then we had state witness Dr. Richard Fries. He's the guy with the handlebar, well, the curvy mustache that's in the thumbnail for today's show. And he just talked about the injuries to the victim, and there was nothing about the injuries that was inconsistent with self-defense. The bullet came in the upper left, passed directly through the heart, through the liver, through the diaphragm, into the kidney. It was a mortal wound. Even if she'd been in an emergency room, she couldn't have been saved. There's criticism of the officer, Aaron Dean, here, because he never provided aid to this victim. But the truth is, aid would have been pointless. It was a mortal wound. He may have observed that. But in any case, other officers were on the scene within moments and pushed him aside, appropriately so. He's the guy who fired the shot. There's going to be an investigation, and attempted to provide life-saving care to the victim here. But of course, it was pointless. They showed the officer's gun. They showed the bullet. Death would have been very quick. Cross-examination. So the state really didn't accomplish anything here. There was some hint that the angle, the state tried to imply the angle of the shot might have been inconsistent with the narrative of events, but not really, because of the angle involved was very slight. It was consistent with the victim facing the officer, maybe leaned forward, crouching forward a little bit, as somebody might if they're preparing to defend themselves against an apparent intruder outside, which is what this victim probably thought she was doing. And Cross just reaffirmed that the angles, the cross of the medical examiner, the angles involved here were not inconsistent with what the defendant here had described happening. Then we had, then we had an odd witness, Ashley Carr, who was a sister of the victim, and she provided no substantive value. Of course, she has no firsthand knowledge of the event. All she could talk about was how awesome her sister was. Apparently, she wanted to go to medical school and cure diabetes, which is great. Great aspiration. And there was a second police officer. I must have missed putting down his name here. Another crime scene investigator. But again, he didn't have anything of substance to add. There was nothing he observed that was inconsistent with the defendant's narrative of events here. And it was after the sister, the pointless testimony by the sister, all it could do was be prejudicial against the defendant. It couldn't be relevant in any way. That the judge suddenly announced that he was going to clear the courtroom, cleared the gallery, sent the jury out, said he had things to discuss with the lawyers. The cameras went off. That was the end of the streaming from the courtroom. And then I found this news story that the state had rested. The state had rested. And that was all that was going to be covered by the state. Now, in fairness, whoops, that's not what I wanted to do. Let me make this a little bigger, make this a little smaller. So try to get rid of this ad. Yeah, the announcement came as a surprise. The final witness was the sister. The crime scene investigators just explained how they investigated the scene, but again, there was nothing inconsistent. There was nothing from the medical examiner that was inconsistent with the defendant's narrative. That's the sister there, the last witness before things were dismissed or before the state rested. Presumably, by the way, yesterday afternoon, after the state rested, one of the things that happened, of course, the media is not reporting it because they're stupid and don't know the right questions to ask, is that the defense made a motion for a JOA, a judgment of acquittal, arguing that the state had shown nothing that a rational jury could use to arrive at a finding of guilt. In fact, the state had done one tiny thing, and that was to change the testimony of the 8-year-old. The 8-year-old saying the aunt wasn't raising the gun. The testimony on the witness stand that was immediately contradicted by that same witness's own contemporaneous testimony 2 hours after the event that the state had, that the aunt had pointed the gun at the window. How much credence can you give that changed testimony 3 years later when there's incentives to change the story? Not much, but it's more than zero. I mean, in theory, a jury could give that one little scintilla of evidence 150% of the weight over everything else that's presented in this trial. That's up to the jury to do. So a judge would likely point to, if nothing else, point to that, the only thing that the state seems to have accomplished here. And as weak, as impeached as it is, and say, nope, judgment of acquittal is denied. We're going to send this, have you present your case in chief, and have the jury decide. I'll also note, yeah, the sister's testimony was so pointless that the defense didn't even cross-examine her. So let's see. Yeah, now the case goes to the defense, but they don't have their witnesses ready. They weren't anticipating they were going to have to start Wednesday afternoon, that the state was only going to present 2 days of testimony, effectively. So the court's going to give them the opportunity to do that. Now, the state, this is a good point. The state's going to have a rebuttal opportunity. So the state will get the opportunity to present more of their case after the defense rests. But in theory, they're only allowed to present things that will rebut the defense. So is this a strategic move by the state to say, hey, let's hear what the defense case is going to be, and then we'll present more evidence to rebut their case? It's not really how it works, folks. I mean, normally you would expect the state to present 95% of its narrative to the jury in its case in chief. And then if the defense says something weird that the state wasn't anticipating, makes a point, calls a witness says something unusual, like happened in the Derek Chauvin case, for example. There was expert testimony that apparently the state had not anticipated. On those particular little narrow points, you can present rebuttal evidence, but you don't get to present a case in chief again on your rebuttal. So no, I don't think this is a strategic move. I just think the state has no case to present. That certainly seems to be the case from the very beginning. In the state's opening statement, it was 98% emotion. Just look at this photo. That's what the state's opening was like. This lovely woman wanted to be a doctor. This 8-year-old child, the poor child, had to witness this tragic event. And it is a tragic event, folks. No one thinks the victim here was doing anything that she deserved to be killed. It was an awful, probably lawful shooting here. But so no one thinks this was a good event. Everybody, including the defendant, I'm sure, wishes the victim was still alive today, that he hadn't been compelled to shoot her. But that's all the state's opening statement was all this emotion. And then at the end, they kind of summarily said, the prosecutor, a woman, summarily said, we're going to show you, ladies and gentlemen of the jury, that this was murder and it was not self-defense. Done. I mean, there was no substantive reference to law, to evidence, to how they were going to disprove self-defense, what the evidence would actually show the jury that was inconsistent with self-defense. And now we know she didn't say any of those things because she doesn't have any of those things, or they would have shown them in their case in chief. Then in contrast, we had the defense opening statement, which was rich in evidence, rich in law, very substantive, not emotive, a much, much stronger opening for the defense because the defense actually has the law and facts on its side. Right? When you have the law, you pound the law. When you have the facts, you pound the facts. When you don't have either of those, you have to pound the table. The prosecution was pounding the table in its opening, and the defense was pounding law and facts. And that's by far the much stronger position to be in. Let's see. Someone the quoting here, I think it's a local lawyer, says, I don't believe we've heard all the evidence yet. What we do have is 2 police officers, the defendant and the female backup, on the scene in substantially similar situations, making different decisions at the instance in time. Well, first of all, that's allowed. Second of all, they weren't in substantially similar situations. They were back to back. Only the defendant here was looking at the direction of the threat. The female officer was looking in the opposite direction, covering their rear in case this apparent burglary in progress, they encountered more bad guys. So she didn't observe what the defendant observed before the shot was fired. She heard the shot and turned around. She heard his verbal commands, quickly followed by the shot, and then turned around. So they're not in there's a reason she didn't shoot. By the time she would have known what to shoot at, it was over. So of course she didn't shoot. The defendant only fired once too. All right, so that's where we are with that. Of course, we expect the trial to continue on Monday. So I won't be streaming anything about the trial tomorrow, I guess. There won't really be anything to talk about. What I can do right now is, because it only takes a minute and a quarter, is show you the body-worn camera footage again. This is from the moment the cops arrive at the front door of the house. The house looks disheveled. There's stuff all over the floor inside the house. The female cop who testified for hours said it looked to her like the house had been ransacked. It looked to her like a burglary in progress. They began to investigate around the side of the house, and within a minute of a quarter is when we have the defendant here look through the window, see the apparent threat inside, give commands, fire the single shot. So let me pull up the body camera footage, and we'll go through that. There's no gore here. This is the publicly released camera footage, so it freezes at the moment the shot is fired. There's also stuff all over the ground outside, a lawnmower, a weed whacker, a bicycle, which burglars often do. They're clearing the cars here. You'll see a glimpse of the female officer to the left. They go through this gate, and then the windows on the left commands, and the shot is fired.
Put your hands up! Show me your hands!
And that's it. That was the single fatal shot. All right, folks, that's all I have time for. I have to get to my doctor's appointment, but I wanted to share that news with all of you. Not sure what the rest of my week looks like. We'll have to see. But on Monday, I plan to be streaming this trial again, either on my own channel, or if Nick Rekieta Law wants to take over the streaming of the trial, I'll join him on his channel for that. But we'll let you all know about that as that develops. All right, folks. With that said, I want to wish all of you a great week. And until, remember, if you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill. So my family is hard to kill. So you owe it to yourself and your family to also make sure you know the law, so you're hard to convict. Until next time, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.